In this lecture, we are going to talk about terms of contract of sale of goods for commercial law for business students, for Al-Isra University students. Commercial law. Terms of contract of sale of goods. We are going to verify and shed some light on the terms. First of all, the price. The price in a sale of goods contract, there must be a money consideration called the price. So we have to have a price to pay for the goods that we are buying, or on the other hand, the person who purchased actually the goods has to pay the price. This usually includes any form of payment except trading by barter, which is exchange of goods for goods without money. Such price can be payment by credit card, check, bank draft, etc. in any ways or means of payment. There must have been an agreement for the payment of a fixed price, acceptable price of course, or acceptable ways or means of paying the payments, a fixed price without which there will not be any contract. Excuse me. The subject matter goods. The subject matter goods. Generally, goods are defined as to include all chattels, personal other than things in action, and money, embellments, industrial growing crops, and things attached to or forming part of the land, such as agreed to be served before sale or under the contract of sale. So we are both of the parties abide by the contract and the conditions of the contract. Real estate versus goods. The dilemma is this: a landowner enters into a contract to sell crops, timber, minerals, oil, or gas. If the item have already been detached from the land, for example, timber has been cut and the seller agrees to sell logs, they are goods, and the commercial law governs the sale because it is detached from the land itself. Trees. But what if at the time the contract is made the item are still part of the land? Is a contract for the sale of uncut timber governed by the commercial law or by real estate law? We're going to talk about this dilemma, or this question actually. The commercial law governs under either of two circumstances. Number one, if the contract calls for the seller to serve the item. First of all, to serve the item, the trees on the piece of land. Or number two, if the contract calls for the buyer to serve the items, and if the goods can be served without material harm to the real estate. These are the two things that governs by the commercial law. The second provisions specifically includes growing crops and timber. By contrast, the law of real property governs if the buyer's servants of the items will materially harm the real estate. For example, the removal of materials, oil, gas, and structures by the buyer will cause the law of real property to govern. Goods versus services. Distinguishing goods from services is the other major difficulty that arises in determining the nature of the object of a sales contract. This is goods, material, and services tangible and intangible. Goods tangible, the services are intangible actually. The problem: how can goods and services be separated in contracts calling for the seller to deliver a combination of goods and services? How? That issue is examined the predominant factor. Predominant factor, or the test where the courts applied the common predominant factor. Predominant factor, which of them? Goods or services? It asked whether the transaction was dominantly a contract for goods or services. To verify and to understand the nature of the two of them, the goods or services, and what the predominant factor, the goods or the services. However, the results of this analysis are not always consistent. Excuse me. In two areas, state legislatures have taken the goods versus services issue out of the courts' hands and resolved the issue through legislation. Food sold in restaurants in a sale of goods, whether it is to be consumed on or off the premises of the restaurant, inside or outside the premises of the restaurant, or the land of the restaurants, of course, inside or outside. Blood transfusions, really the sale of blood. Blood transfusions, really the sale of blood in hospitals, have been legislatively declared a service, not a goods, not a sale of goods, thus relieving the suppliers and hospitals of an onerous burden for liability from selling blood tainted with the undetectable hepatitis virus. So it's services, not goods, to actually get out from the dilemma of blood transfusions, if there is hepatitis virus or not. Categories of goods. Categories of goods. There are different categories of goods, and they are categorized as existing goods, specific or ascertained goods. Number 3, goods sold by description. Number 4, future goods. So they are existing goods, specific or ascertained goods, goods sold by description without seeing them, or future goods, they are in the future. Existing goods. They are goods that are owned and possessed by the seller at the time of contract. This can be meant to be that they are goods actually in existence when the contract is made. There is no problem for that. Such existing goods may either be specific or uncertain. Specific or uncertain. Number 2, specific or ascertained goods. They are goods identified and agreed upon at the time the contract of sale was made. For example, a 2012 Yamaha 2012 Yamaha motorboat with engine number 10375 and chassis number AS60391. This is specific goods, uncertain goods. Goods sold by description. There are goods sold by description but which were not identified or agreed upon at the time of the contract but are included in a particular class of goods. For example, 10, 18 kilograms mahogany wood. Future goods. There are goods not yet in existence and goods in existence but not yet acquired by the seller. This is to say, goods yet to be acquired or manufactured by the seller after the contract has been made, such as a sale of 200 tons of potatoes to be grown on a piece of land was held to be a sale of a specific goods, despite the fact that they were not existing goods. So they are in the future actually.